Good morning, and my name's Emma Lindsay reporting to you from CNN. Nebraska decides a 12-year-old must give birth because she isn't mature enough for an abortion. The highest court in Nebraska has decided that a 12-year-old must carry her unintended pregnancy to term because she hasn't proven that she's sufficiently mature and well-informed enough to choose to have an abortion. The 12-year-old sought to bypass the state's parental consent law because her parents are very religious, and she worried that she would lose her place in their home if she told them she wanted to end her pregnancy. Under the state's current law, minors must obtain notarized legal consent from a parent or guardian before being allowed to have an abortion. There are three exceptions: medical emergency, situation when there's proven abuse or neglect in the home, or a situation when the court agrees that there's clear and convincing evidence that the pregnant woman is both sufficiently mature and well-informed to decide whether to have the abortion. That's a particularly harsh abortion law for minors. Nebraska used to require minors to notify the parent or guardian about their intent to have an abortion, but didn't require them to obtain notarized consent in order to have the procedure. The state toughened the requirement in 2011. And in a 5-2 decision led by Peter Pedalian, the judge, the court ruled that the 12-year-old didn't fit into any narrow exceptions granted under the state's new parental consent law. They decided that her history of parental abuse didn't count as the type of abuse in the home to qualify for that type of exception under the law. They also concluded that the 12-year-old failed to establish by clear and convincing evidence that she was mature and well-informed, so she couldn't seek that exception either. Battalion appears to have a history of anti-abortion activism. The AP notes that he may have served on a committee for an anti-abortion group in Omaha during the 1980s, although they haven't been able to confirm that with him. Daily Kos points out that he has served as a defense attorney for members of the militant anti-abortion group Operation Rescue, as well as an anti-choice activist who was arrested for stalking abortion providers. And a 1994 newspaper article about the debate over the state's parental consent law quotes Battalion as speaking on behalf of a group, Lawyers for Life. RH Reality Check notes that the decision has potential implication for future wards of the state. If other minors in foster care are subject to the whims of court, they may also be denied the right to have an abortion simply because of a conservative judge on the bench. But that may be the end of global policies. That may be the end goal of policies like Nebraska's anyway. Ultimately, parental notification laws simply serve to obstruct abortion access. Physicians for Reproductive Health, a doctors group that works to expand access to reproductive health services, opposes these type of laws simply because they end up delaying time-sensitive medical care. The young women who choose not to tell a parent to do so for a number of good reasons, including fear of abuse or abandonment, or because they don't live with their parents. When the state interferes with a minor's decision about abortion or birth control, it forces the teen to choose a parent over another trusted adult who might be better suited to support her. Let's talk about the laws now. So in California, in our Golden State, abortion laws are less restrictive than those in many other states, which impose long waiting periods, consent requirements, strict facility codes, and other statutory obstacles. The Golden State allows nurse midwives and other non-physician medical professionals to perform the procedure. But all state laws, including California's, have some abortion restrictions. For instance, California requires unemancipated minors to seek parental consent before getting an abortion, and it is illegal without written consent of the legal parent or guardian. Abortion laws are constantly changing, especially as more time passes since the biggest abortion case, Roe v. Wade, was decided. Ever since then, abortion in the United States has been legal, and women have had a right to choose whether to have an abortion during the early stages of their pregnancy. However, states are allowed to regulate certain aspects of abortion during the first trimester, such as imposing counseling, waiting periods, and other requirements. During the third trimester, there is generally little to no legal way to have an abortion unless your life is in danger. So now let's talk about Nebraska and compare those laws. In Nebraska, certain restrictions were as in effect as December 1st, 2015. A woman must receive state-directed counseling that includes information designed to discourage her from having an abortion and then wait 24 hours before the procedure is divided. The parent of a minor must consent before the abortion is provided, as well as public funding is available for abortion only in cases in life endangerment, rape, or incest. When comparing the two laws, California seems much less restrictive than Nebraska, just based on the fine print. Counseling before being able to have their abortion, it seems that Nebraska really wants women to think this through. Social contract theory. This is the view that a person's moral and political obligations are dependent upon a contract or an agreement among them to form the society in which they live. I think the social contract theory is fitting for Nebraska, this particular case study, in light of the laws that are in place. In this case, I think the contract would be in favor of the unborn fetus versus the 12-year-old mother. Keep in mind that abortion became legal not that long ago, and many still deeply oppose it. A social contract protects the person's individual rights, but also the rights of others. I'm thinking that this protects the fetus, as well as a family or parent's decision. The laws or contract do not allow a minor to make this decision without notification and consent of the parent or guardian. Like a social contract, the laws are spelled out clearly, and pregnant minors are drafted into this without consent since they are underage. Maybe they did not ask to be pregnant, but they did have to abide by the law and their families. Which lies on another point of view. If the family itself is a social contract and the decision to get an abortion is among them, social contract theory would say children deserve more, but not all consideration. The major moral issue in this case is that the child does not want to go through with the pregnancy, but is being forced to because of her age. There's also a moral issue in the fact that the judge appears to be biased because of his anti-abortion history. For future cases such as this one, there should be some type of exception in the law for discrepancies like this. A person should be able to have the freedom of choice no matter the age, hopefully with parental consent and notification. In a happy world, the parent and child would both agree on an outcome and there would be no case whatsoever. This is rare. If the child does not want to carry out the pregnancy and has valid reasons why, then there seems to be no reason why they shouldn't be able to go through with an abortion, health risk being a main one. I think that parent notification is necessary, but parent or guardian approval should not be mandatory. The child's case and reasoning for not having parent approval should be explained and assessed, but by someone who is free of bias, and then perhaps given another 24 hours to assess their decision. If grown women can have counsel for this decision, children especially should too, regardless of what state they are in. Maybe some think that this would lead to turmoil and that children would be going around having abortions everywhere. I beg to differ. If this policy worked for an extended period of time, then what is to question that it could work again? Thank you. Once again, Emma Lindsay for CNN News.